morning, everyone. My name is Kaylee Lauder, and I'm the current treasurer of Silicon Flatirons student group. And as a partner of Silicon Flatirons, we host a lot of events for students, which kind of primes them and gives them a little background for conferences like this. And we also host forums for them to engage with some of the speakers. So yeah, and we also help students find mentors and jobs and internships. So if any of you have any desire to engage with the student group, I'm happy to let you know of opportunities to get involved. And it is my absolute pleasure to introduce our next panel, the Copyright Law of Generative AI, moderated by Professor Surden.
Great, thank you so much for that introduction. Really appreciate that. I'm Harry Surden. I'm a law professor here at the University of Colorado Law School and also the faculty director of our Artificial Intelligence and Law Initiative at Silicon Flatirons, and I research issues related to artificial intelligence and law. I want to thank Professor Blake Reed for organizing such a terrific conference, Professor Bernthal for organizing this, and as well as the terrific Silicon Flatirons team for doing such an amazing job. So please join me in a round of applause for those. Thank you also to Registrar Strong for such an interesting presentation. I learned so much. Joining me today are a terrific panel of experts. In the interest of time, I will only provide a very brief introduction, but I encourage you to look at their extensive bios online as they have very impressive accomplishments. To my left, I have Andy Gass, who's a partner at Latham and Watkins, and who runs a copyright practice, and he's been involved in many important copyright cases involving AI. Next is Cynthia Arato, who is a partner at Shapiro, Arato, and Bach LLP, who is a well-known IP litigation practice generally, and specifically within artificial intelligence itself. Next is Viva Moffat, professor of law at our friends down the road at the University of Denver, who is a well-known expert in intellectual property law and an important commentator on AI and copyright issues. Next, we have Professor Oren Bracha from the University of Texas School of Law. Professor Bracha is a scholarly expert in intellectual property and in particular the history of intellectual property law. And he's also written extensively about AI and copyright. And last but not least is Katherine Lee, who is a PhD candidate at Cornell University, who is a leading voice in AI language models and copyright and privacy. So we have this terrific panel of experts. These are the right people here at the right time at this issue that is generating tons of interest among the public. Before we get to our questions, I'm going to provide a little bit of background. I know that not everybody is an expert in copyright or AI, or maybe some of you were just joining us and didn't get either access to the primer yesterday or to the introductory remarks. So let me just try and situate the questions generally before we hear some of these ideas from our expert panel. So let's begin with the basic question: what is generative AI? And I think it's worth explaining that. Generative AI or artificial intelligence is the umbrella term for artificial intelligence uses in areas of human creativity, such as art, music, language and text, video, etc. So what does that mean? Well, artificial intelligence can be used in lots of different areas outside of human creativity, prediction, self-driving cars, robotics, identifying cats in photos, what have you. So when you're using artificial intelligence for particular uses associated in areas of human creativity, we call it generative AI. So how does generative artificial intelligence relate to copyright? We will see there's lots of different ways, as Registrar Strong talked about, but there are two main ones that have dominated the discussion. The first is the use of copyrighted works for training artificial intelligence systems. I'll have more to say about that in a second. And the second is whether works produced by artificial intelligence systems should be copyrightable, something that Registrar Strong discussed. So let me just give you a brief background of the first and the second and why they're related, and we'll to copyright law, and then we'll throw it to our panels for some opinions about how we should solve all this. So generative artificial systems like ChatGPT, many of you are familiar with that, produces fluent like text. In other areas, we have generative AI systems like Midjourney, which can produce art, or DALL-E, also generative music systems. These are part of an artificial intelligence approach known as machine learning. And what machine learning does is it needs to be exposed to a large amount of data and learns patterns in that data to be able to produce large amounts of text. So that's called training. For example, ChatGPT, how did it learn how to produce fluent human-like text? It was exposed to billions of words, a large portion of the internet, and it learned the various patterns of language and thought among those documents on the internet. Similarly, how did Midjourney or DALL-E learn how to make images, novel images like the one that Maria Strong showed? It was exposed to lots of different photos and paintings and drawings out there on the internet and learned the patterns encoded in those pieces of art. So that's known as training. Now, importantly, most huge percentage of those things, either text or images that these systems were exposed to, are copyrighted. So that's where copyright comes into the picture. So, and the question is that permissible under copyright law to use copyrighted images or text to train an AI system, or is it not permissible? And then the other question is, what about art that is produced by these systems, right? Is the art or the text produced by ChatGPT, is the text copyrightable? Is the art produced by Midjourney copyrightable? We've already heard an opinion from Registrar Strong. So where does this fit into copyright more broadly? So copyright law is primarily about allowing the creators of creative works to capture the monetary value of their works by stopping others for using their works without paying or paying too little. So that's one main value. On the other hand, we have something called fair use, which is an important aspect of copyright law as well. So fair use is permission-free uses of copyrighted works that are not infringement. So think if you're quoting a news article that has a criticism of somebody's book or something like that, that would be your prototypical use of fair use. So fair use is typically around education, speech, criticism, and also transformative art, and in some cases, allowing technology to work together. So when we have these two main pillars of copyright clash, we have artists and creators trying to get the values of their works on the other hand, and the uses of these works for other things that society deems important, whether technology or art or speech or criticism. This is where these things clash. And that's what we have today in the world of generative AI. We have AI, which is deemed as very important and is helping a lot of discoveries. On the other hand, we have creators whose creations who are being used without their permission and who feel like they should have some say in whether their creations are used at all, or maybe they should be compensated for that. So with that background, let me dive into our first question for our first panelist, Andy. And let's talk about fair use. Should AI companies be allowed to use copyrighted works in training? And then kind of the subtext of that is should that be considered fair use under current law? Is it fair use under current law? And what are sort of the pluses and minuses of the situation? And then we'll open it up to the rest of the panel to weigh in on this. So Andy.
Thanks, Harry, and thanks so much to all of you for having me here. It's a great privilege to be with all these people, and hopefully we're going to have a lively conversation about these issues. I should make clear at the outset, I'm speaking in my capacity as a private citizen, not on behalf of any clients whom I represent in this area. So I guess I'll answer that question by starting with a slightly more detailed overview of what is happening in these technologies, and then maybe do a slightly deeper dive into how I see the law working. So when we talk about companies using copyrighted content to create generative AI models, we're basically talking about taking, either pursuant to some contract with someone or not, unimaginably large quantities of the medium at issue. Take text, for example, at billions or even trillions of words that are found sort of somewhere in a state of nature, whom someone wrote at some point. And what the technology does is it feeds all of these discrete components of text into a neural network of some sort, right? And the purpose of that is to allow the network to, as you alluded to, kind of derive almost incomprehensibly large volumes of statistical insights about the underlying correlations between the constitutive elements of the texts that are being fed. So in a sense, what is being done is like no human being is seeing these texts, right? They're being tokenized, broken apart, and studied by this computer program, which is then saying, aha, I have determined, to take a radically overly simplistic example, if the first two words that I see are today is, the next two words are much more likely to be a Friday than a bookcase, right? And it's those kinds of insights performed at, again, an almost incomprehensible scale in when I say multi-dimensional vectors, these are 75 dimensional matrices of sort of correlations and statistics that allow the tools to then generate something in response to a query. And there's a bunch of other stuff that happens between the creation of what's called the large language model and the output, but at bottom, we're sort of focused at the initial phase in the fair use question on what's going on with the copies that are made, right? And for sort of the base case that I'll describe, and this may not be all cases, but for the base case that I'll describe, imagine that what's going on is that the company has, factually made a bunch of copies, in the copyright law sense of that term, of copyrighted material, here, texts in the example I've been talking about, in the service of teaching this model to, after a bunch of human intervention and fine tuning, spit out things that do not themselves resemble any particular item that was in the training set, right? So that's the case that I want to talk about in the first instance. So for example, we're talking about teaching a model to produce an output that says hey, Andy Gass's bespoke generative AI model, who was the greatest basketball player on earth? And the model says, opinions may vary, but I think the leading answer is probably Michael Jordan, right? That's the kind of thing we're talking about. We're not talking about, hey, model, please regurgitate for me the first chapter of Harry Potter, and it gives you that. That implicates a different set of issues. So in the base case that I'm talking about, the legal question presented is, we have a bunch of copying that has taken place, and in our system of copyright law, the copyright owner is the one who has the exclusive right to reproduce a work in copies. That's 17 USC 1061 for anyone following along at home. But that's not the end of the story, because it's not an infringement if those copies were fair use. Okay, so that then brings us to the question of, how do we think about fair use in this context? So fair use is a doctrine that in the American legal system goes back to at least the sort of mid-19th century. Justice Story is the one who's originally credited classically with having sort of devised the doctrine. There are traces of it in the sort of the English system that predates the ratification of the US Constitution. And the current embodiment of the doctrine is specifically, if you sort of look at the legislative history of the statutory provision at issue, which is section 107 of the Copyright Act, it's specifically intended to sort of instantiate the common law tradition that predated the codification of fair use in the Copyright Act at all. So what that usually means is, while we have these sort of 4 factors that are written into the statute that I will not burden you with right now, from the text of them, it's probably difficult to figure out how any given dispute would be resolved properly. And instead, what we do as lawyers is think like, well, we've got, close to 200 years of history of judges dealing with kind of situations that may or may not be analogous, or maybe analogous in certain respects, but not others. And if you sort of put together that constellation of precedent, where does this fact pattern line up? So you can think about it from first principles, but the way that we really do it is by reference to these pre-existing judicial decisions. And so what are the relevant judicial decisions in this circumstance? So as Harry, I think, rightly alluded to, there is a whole long line of cases in the federal courts in the United States that deal with the question of when and to what extent a technology company can make copies of copyrighted works, not for the purpose of like showing those copyrighted works to the public, but instead for the purpose of creating some new and innovative product that didn't exist anymore, right? And the courts have sort of grappled with like, do we always allow that? Do we sometimes allow that? What are the circumstances in which we allow that? And in my view, the kind of general rule that emerges from those cases is a principle that says, in that circumstance where what is happening is the technology company is factually making copies in the service, but not showing them to people, in the service of creating a new product that didn't previously exist, the courts are going to call that back end, invisible to the public copying fair use, to the extent that the output of the process would not itself be a copyright infringement if it had just come to be without all of that copying that took place. So what do I mean by that? I mean, take for example, the case of a video game company. And imagine that there's a proprietary operating system that a technology company runs for a platform for operating video games. We'll call that company Sega. Okay. So Sega has an operating system, and Sega has its own video games that run on the operating system. And imagine that you have a challenger who comes along and says, I would very much like to create my own video games to run on your operating system Sega. And imagine that Sega says, no, thank you. Our system is a closed system. It's a copyrighted product, our operating system. You may not interoperate with us. And imagine that this challenger video game company comes along and says, well, I take your point, Sega, you'd prefer that we not do this. But what I want to do is just study your operating system so that I can technologically figure out how to make a video game cartridge that's going to work when someone plugs it into the console that you've created. And I'm going to do that. I'm going to create as many back-end, invisible to the public copies as I need to of your copyrighted operating system, in the service of what? In the service of producing my own new video games. And they're not going to be copyright infringements of your video games, right? They're going to be different video games. But they are going to compete with your video games, so we're clear. In that situation, the precedent that we have is that the court says, fair use. You are allowed to do that. Similarly, imagine a company that says, I would really like to create a product that makes the texts of books searchable for people. And I'm going to do it in a way that says that when someone inputs their search query and sees a result returned, what they get isn't going to be like the full text of the book. It's just going to be like a little snippet view of the book. And I'm going to be a little thoughtful about it to make sure that like a dictionary definition where the thing itself would be a complete substitute for what the copyrighted work was is not going to be displayed to the public. Imagine that I want to do that, and imagine further that the authors of sort of all of the books in the libraries of Harvard University, UC Berkeley, University of Michigan, and a number of other libraries come together and they say, over our dead bodies, are you going to do that? We wrote those books. That content is ours. You can't do this without permission. In that circumstance, what the courts have said is that all of that back-end copying, in this, again, scanning physically and creating permanent digital lasting files of the full text of all these books is fair use because it's in the service of creating this non-infringing output, these snippet views. So what do we as lawyers do with this? We think, to what degree is this analogous to the base case of generative AI that I described? To what degree is it disanalogous? And kind of the punchline is that from my perspective, the answer is those cases are very instructive. And what they mean is that the existing law that we have for the base case that I described spits out the result that all of that back-end copying in the service of creating non-infringing outputs is fair use.
Okay, great. Thank you so much for that. So what I'm hearing from you is not only should it be fair use in your opinion, it is likely fair use under current doctrine. Yeah, so I can see the fellow panelists very excited to answer. So let me see.
I thought that was unassailable.
So let me see what Katherine has to say about this, and then we'll turn to the other panelists because I know they've got thoughts as well.
So I am first and foremost a machine learning researcher, and my research is predominantly in the memorization of training data and training data extraction from large language models. So with that in mind, your kind of discussion rests on the premise that the output is not infringing. My research, and my co-authors would be very upset with me if I didn't bring this up, is that a lot of the outputs are duplicates of examples in the training data. Arguments that I've heard for why that would be fair use are that the process itself is transformative, but this argument together feels a little circular because it's saying that because the output is not infringing, because the process is transformative, therefore the process is transformative. So obviously this is not the case with every single situation, right? Because not every output coming out of a model is an exact copy, and by and large, the majority of outputs are not. But there is 3 different cases that we should consider here. One is the situation in which they are, one is a situation in which they are not, and the much harder case, which is the situation in which they're kind of similar but not really related. And so I would love for you to expand on the different cases a little bit more, because we've predominantly focused on just that second one.
Yeah, I'd be happy to do that. So, so I think we have common ground on the following points. It's not controversial under existing copyright doctrine to suggest that in the scenario where the output of a generative AI model would not standing alone be an infringement, that's fair use. I think we have common ground on the proposition that the majority, you say the majority, I would say the overwhelming majority of outputs are not copyright infringements in that sense, right? They are not what the doctrine would call substantially similar to any particular work in the training corpus. So for that vast majority of outputs, there shouldn't be much of a question, I think, between us, that the use of the training data to generate those outputs was permissible. The question,
This is challenging, right? Because the substantially similar question is really challenging. And to go back to how these models are trained, they're not trained to say, reproduce the first chapter of Harry Potter as a response to, please reproduce the first chapter of Harry Potter, but they are trained to produce the next word that in the sequence that they are seen. So this is it's a bit challenging here. And especially when you get training data into large quantities, you get distributions. And distributions are much more concentrated in the areas that you have more data and less concentrated in other areas. So the questions of whether or not things are similar primarily, to my understanding, fall into that third category of where things are maybe similar in some ways and not similar in other ways. And again, not saying that all the ways in which they're similar are problematic, because there's a lot of things like facts that we know are not copyrightable. So figuring out and teasing away that part feels like it's, as you said, more of a case-by-case basis. But to go back to where this is coming from, I'd just like to say that I feel like this is more of a case-by-case basis and more of a case-by-case into how the models themselves are also created, because not all models are created equal, right? We mentioned before that some models have smaller training data sets. Some models have larger training data sets. Some models contain licensed work. Some models contained copyrighted unlicensed work. And so depending on the way that the models are structured and the way that they're designed, that can impact the copyright analysis as well. So to lump everything into one category is easy to do, but I think I would like us to tease this apart a little bit more and talk about like the different ways in which these scenarios might come up.
Totally agree. I was actually specifically trying to tease out the categories, but I actually wanted to ask you a question. And sorry for derailing us a little bit, but I don't get an opportunity every day to talk to a machine learning researcher. So, so you mentioned that there are not all models are created equal, and that there are models that are trained on less stuff, and there's models that are trained on more stuff.
Yeah.
And that you study memorization, which I think, sort of for the folks who are listening at home, means the circumstance where the model spits out something that's like a verbatim replication of something that it was trained on. So it's not, who was the greatest basketball player of all time? Probably Michael Jordan. I don't know. Reasonable people can differ. It's like it gives you someone's pre-existing analysis of that question, right? Not a result that I think virtually anyone wants to see, but a thing that happens. So my question for you is, as a technological matter, to the extent you can generalize at all, which you may not be able to, does it tend to be the case that that kind of memorization or verbatim regurgitation is more likely the smaller the training data set is, or vice versa, or can we simply not say?
This is a complicated question, and I'm going to back it up first. So when I say memorization, we have a lot of different intuitive definitions of memorization, one of which is memorization of fact, one could be memorization of style, one could be memorization, as you said, of an exact training data. I'd like to offer that even approximate memorization, approximately getting it right, is also perhaps troubling. The question about whether or not a smaller data set, a model trained on a smaller data set, is more likely to memorize more data depends on how long it's been trained for, the architecture, and the training dynamics. So what I'm talking about there is the learning rate and the learning rate process throughout the entire training. This is just within the model itself. So I can't answer your question in that framing, but I can tell you that depending on choices that are made, there may be different outputs.
If you hold everything else constant?
I can't hold everything else constant, and I'll tell you why. Because if I want a model trained to a certain quality, that means that I have to adjust a lot of different knobs. So if I have a smaller model and a bigger model, and I want them to get to the same quality, I'm going to have to make a lot of very different decisions, including the training data, including the training time, including the training process.
Let me just pause for a second because I see some of the other panelists wanting to jump in. Cynthia, did you have something you wanted to say?
Yeah, I do. So I'm going to start by saying I do agree with Andy on the fact that I'm speaking just for myself.
So we have one area of agreement. That's
I'll
good.
second that one too.
We'll take that.
It's the most important area of agreement. So I think that I'm just going to speak quickly because we have a bunch of questions to cover, but I think that the models on the training are copying expressive content. I'm going to just talk about text models right now, large language models. They're ingesting expressive content for the purpose of extracting that expression so that they can mimic that expression when they do their outputs. And I think that capturing of the expression is the heart of what copyright is supposed to protect, and that whatever else you want to say about these models, whether the output is infringing, it's not infringing, I don't think there is such a thing as a base case that you can analyze these models saying the only thing they output is non-infringing, because that's just not how they work. But the capturing of the expressive content means that it's being used for what copyright is supposed to protect, and therefore the use of that content without compensation or consent, I think does violate the copyright rights of the content owners, and that it doesn't translate to being a fair use. There's, I think, a big debate out there as to whether the models are copying expression. I know Andy talked about how they they're being fed discrete components of text, disaggregated, but I actually would disagree with that. I mean, that they might, in their training and in the process, disaggregate the text, but if the point is for the model to see what a full sentence is or a full paragraph is so that it can then code those words so that it can mimic human speech when it's producing an output, it has to be ingesting full sentences and full paragraphs in order to accomplish that. And I think the fact that what it is doing is copying expression can be gleaned from what you see in the output. So memorization is one of those things, that if it is possible through the statistical probabilities that the model comes up with, having looked at the text, to replicate the text, even if that's an undesired result, I think that proves that the expression has been obtained and retained by the model. There's a phenomenon known as hallucination, where the chat bots of the world are known to provide responses that include facts that are not correct. And I think that they couldn't have ingested from anywhere because they're made up. And I think that shows that the models are not merely trying to glean facts divorced from expression, because they're not able to actually know what's a fact and what's not. They're just giving you a prediction on the next word. They can't extrapolate. Models can't extrapolate. So there's a recent paper that's come out that if you ask the chat box, who is Tom Cruise's mom, it can give you the answer. But if you ask chatbot who is Mary Lee Pfeiffer's son, it tells you it doesn't know. So I think that all of that together shows that the models are not actually learning or just trying to obtain fact. They're just copying expression so that they can also be expressive. And then I'm just going to quickly touch on the back end cases. So Andy was talking about Sega and the famous Google Books case. And I think those are they can be differentiated pretty easily from the generative AI world. So I don't think they're very important precedent to come up with the answer for what is or isn't fair use. So on the Google Books case, the court there said they already were at the outer boundaries of what fair use is. And there the copying was, Google explained that the copying was done just to determine information about a book, not the expressive qualities within the book itself. And I think the court was also heavily influenced by the fact that the output was not substitutional. It wasn't that the output was not infringing, it was that the output was not substitutional. And here you see a lot of substitutional effects from what the LLMs are giving you as output, certainly like for journalism and in news settings. And then on the Sega case, that is a case about computer code, which the court found had like a highly functional aspect, which makes it unique in copyright law. And so it's hard to use that as a model for what happens here when you're really dealing with the expression. And it also found that protecting the code in that case would really enable the owner of the code to get like a patent-like monopoly on computer code, which it didn't have, like through the back door of copyright. And I think that also is just not a concern that's present when you're talking about copying expressive content for its expressive content.
Great. Well, thanks for that other perspective. And what I heard you say is you don't think it is or should be fair use because of, unlike the Google Book search case, it's more focused on copying the expressive elements, which goes to one of the aspects of the fair use analysis. Oren, I saw you had some thoughts.
I do actually, thank you. So, when I listen to those fair use debates, I feel a little bit like an atheist in a theological debate because I have a totally different view I want to lay on the table here, which is training copies as training copies, ignoring everything else that happens down the road, and maybe I'll get to that, are simply not infringing, period, on subject matter grounds, well before we get to ask questions of infringement or fair use at the back end. And to be clear, I know it's a somewhat unconventional view, but it's not some new strange doctrine that I've just invented. I think that conclusion follows directly from the most fundamental principles of copyright law as follows. Basically, when we have physical copies, in which in some technical sense we have expressive works embedded, but nobody would enjoy the expression as expression. No human will ever get exposed to the expression as expression from those copies. That does not involve copyrightable subject matter, period. In fact, what's going on, again, bracketing for a second what happens at the output stage, is it's a classic case of learning. It's a classic case of for what for centuries people were allowed to do under copyright law, to take a copyrighted expression, extract meta information from it in order to produce sometimes new expressive works. In fact, in the training context, it goes well beyond that because we're not just talking about expressive generative AI with the training process. The only difference in the generative AI context is that the technology as it exists today has to generate a physical copy. That's the only difference. But look, if nobody enjoys the expressive content, no human enjoys the expressive content from that physical copy, focusing on the physical copy is an act of basically copy fetishism. It's for some reason we bow to the physical fact there's a copy there, and we ignore the fact that the basic subject matter of copyright is not implicated. No human enjoys the expression from that. That's just irrelevant for copyright. So what I'm saying, I guess, is that we need to correct the right outcome, but the wrong turn taken in Sega versus Accolade all of those years ago and get back to correct copyright principles. Now, just very quickly, Katherine's very, very pertinent intervention. But what happens if at the output there is substantially similar stuff at the output stage that does infringe copyright? Again, first of all, let's be clear. This is just, in the big picture, a small subset of the cases, not just within copyright. There's so much training going on of generative AI that doesn't then generate copyrightable or expressive works, right? Many, many training instances involve copyrighted works. So we have a lot of cases with no expressive output at all. But to your point, Katherine, I think most of us, maybe all of us can agree, certainly those would be cases of potential copyright infringement. The output will be infringing when it's substantially similar. Now there's a whole interesting set of questions of whether and how we can trace that back to the person who trained the system and through which doctrines. Maybe we can, but to my mind, the argument wouldn't be the trainer is the infringer just because they made the physical copies. There might be a line of arguments that connect from the training to the infringing output, but again, not just by virtue of physicalism and copy fetishism.
Okay, that's a really interesting perspective. So just, you dove into the mechanics of copyright law. So just for the audience, we'll kind of explain there are different ways you can not infringe copyright. One way is to copy something that's a non-protectable element. That's not copyright infringement. And so you're more in that spirit that what is being copied is not copyrightable at all. Or we've been talking about fair use, which is given something that looks superficially like copyright infringement, is there a good defense of fair use that would excuse you from doing that? And that's an interesting perspective I hadn't really heard. Viva.
Well, maybe I'll just jump in very briefly. I know we have a lot of questions to get into. So, I mean, I think this is, I don't know, from maybe a slightly different perspective. In some ways, this is exciting, like real disagreement on this panel. And, I think much of the disagreement at one layer of it is about is AI like other copying technology that came before it? And do some of these analogies work, and if so, how? Or is it sort of disjunctive and so different in some ways that maybe some of these analogies don't work anymore? And I mean, that's in the way I've been teaching copyright law for years now is, well, what analogies work and why? And so I'm not going to answer that question at all, but in some ways, I think there are people saying AI is actually different. AI is a different kind of thing. This is not like the copy machine or even digital copying, but is something different. So I think that maybe that thing will sort of, that perspective threads through all of these questions.
Yeah, that's a great point, and that is actually my perspective. I think generative AI is a new enough thing in many dimensions that we haven't seen a close analog in the past, even though superficially it seems similar. All right, let's turn it. Wow, we're only on question 2. You got a lot of questions to get to. And I am surprised that lawyers.
I didn't finish my answer to question 1, Aaron.
Well, you'll get a chance to weigh in on question 2. So this one's for Cynthia. Should purely or mostly AI-generated works be eligible for copyright protection? And part of the background is this idea that maybe we're seeing for the first time users of things like Midjourney can enter, very minimal effort and produce high-quality outputs, high-quality artistic outputs. So I can create art on Midjourney. I don't have any artistic skills, and we usually in the past, time, effort, and skill have been linked to high quality, and now we're in a world where anybody can generate high quality output. So let me throw this over to Cynthia.
Sure. So I think there's a major difference here between can AI generated works be subject to copyright protection and should they? And so the registrar gave you a background earlier this morning about the Copyright Office's idea or position that it can't be copyrightable. And that comes from the text of the US Constitution and the Congressional Copyright Act, and as she explained, there's one district court decision that has held that is correct. But the question of should actually turns this from a legal discussion to a pretty deep philosophical question that is really about humanity and are machines supposed to be treated like humans or not. And so the more I read about this, the more I was really surprised at how philosophical the discussion can get. So I'm just going to go through some of the arguments that I've seen sort of pro and con for why AI generated content should or shouldn't be given copyright protection. And I'm talking here about the sort of purely AI generated content, not the questions about the hybrid type of material that the Copyright Office is allowing to be registered, although that comes into play. So there are a bunch of reasons that people have given why you should or shouldn't recognize copyrightability in generative AI work, and they range from moral to economic to kind of the essence of humanity. So people who feel that these works should not be given copyright protection say that it's not a moral result if you let a machine own something where the machine can't take responsibility for whether it's doing something right or wrong. There's a whole economic argument. The purpose of the copyright clause in the Constitution is to give economic incentive to private actors so that they will continue to generate works that are valuable to society, but the goal is to benefit society, not to benefit the private actor. And so there are questions about whether a computer needs any kind of incentive to create a new work. And if it doesn't, why do we need to give the copyright to the work that's generated by a computer? There are arguments about human exceptionalism, that just the creative process by humans is just fundamentally different than the creative process by a machine in ways that people may not actually really be able to articulate, but I think feel, very strongly, and that the benefit of copyright protection should only be given to that special, human creative force. And then there's just the functional questions about if the output of the machine is indistinguishable from the output of a human being, and the goal of copyright is to increase the production of these creative works, like why shouldn't we give copyright protection to a functionally indistinguishable product generated by a computer? And then there's some practical questions, which is, how can we really determine whether the output of a computer is original? is there a way to do an audit trail to the original data that the computer has been fed? Or how do we know, what do we do when the computer generates the same output multiple times to different people? Those are some of the, I think, interesting questions that get raised when you talk about whether you should provide the protection. And then there's a separate question of the works that are generated by the machines, but with the guidance of a human hand. If there's a sufficient guidance of the human hand, then it should be protectable, but then you get into complicated questions about, well, but who's the right copyright owner there? Is it the person who put the prompts in? Were the prompts expressive enough to warrant the prompter getting the copyright? Is it the machine itself? Is it just the owner of the machine? Is it the human being who wrote the computer code that enabled the machine to function? And I don't think anyone has perfect answers to all those questions, but those are the questions that I see.
That was a terrific summary. Thank you for that. And just, can I put you on the spot and ask you your opinion?
I'm not here to give my opinion on that one. I'm the lead person can just, set the stage.
Okay, excellent. So let me throw this out to the panelists, either for opinions or whether you think we've heard what the current state of the law for purely AI generated works is. Yes, Katherine.
I'll just jump in here and say that the technology is changing a lot, and the ways that we interact with the technology is changing a lot, and the questions about how much creative control someone has also depends on what the user interface looks like for the model. So we talk a lot about the generative AI models, but there's this entire system that's built around them. And so the ways that we interact with the model influences the outputs that we get out and influences the ability that we have to modify certain parts. So for example, some image generation models, you can circle a bit of the image and say, put a dog there. And in some of them, you can even draw a little picture of the dog and use that as a prompt, and it'll fill in the rest of the dog for you, maybe in that little pose. So the ways that we get to interact with the system is going to continue to change as more products get developed and as we play with it more, and people imbue their own creative process to the way that they interact with the systems. So when we're talking about generative AI models, we should really be talking about generative AI systems. So I'll just put that there.
Great point, because we're just thinking about it the way they are right now,
Yeah.
but 5 years from now, there could be fine levels of control that might add the human hand more, and we might be talking about something different. Viva.
Sort of maybe consistent with my prior point on the last topic. I mean, one thing I've really wondered about, I'm not going to answer your question either. One thing I've wondered about is whether this question of whether AI generated work should be protectable is really going to push to almost its breaking point, copyright's current very wide net of any even modestly original thing that's fixed in a tangible medium of expression is protectable. I feel that we are already close to sort of a breaking point when every photograph on my iPhone, is a protectable work, and every tweet that everybody sends is a protectable work. Again, is this a new enough and a big enough change that it's going to push us to thinking, well, maybe we should change the place where the filter is. The copyright filter now is, there's no hurdle at the sort of for the outset of protection. Now, talk about taking us out of step with the world. I think talking like that would be, but I think this question really pushes that issue of whether we really should continue to have this extremely broad initial coverage for copyright law.
Yeah, that's a great point, and it shows another way in which our copyright code, developed in the 1970s primarily, did not anticipate such new technology. And I think lurking on the background is this idea that for human authors, you get 70 years plus life. So if you have your AI system today generate 10 million outputs, 10 million pictures, and we were to make them copyrightable, each one of them could have 140 years of copyright protection with $150,000 worth of statutory damages potentially. So, and that's sort of a different world we lived in when copyright was created at fixation back in the 70s. They didn't anticipate that idea. Did I see another hand from the panel on this issue?
Depends on you. If we want to get to other questions, I'll skip.
Yeah, well, you want to give your quick viewpoint on? Let's
Since you
hear it.
insist, I'll do it very
Yeah,
quickly.
this is a big topic.
Okay, this is a very, I think, very useful, discussion and setting up of the stage. So bottom lines, I think we should actually, at this point, put aside the deep philosophical, metaphysical questions, although it's an endless source of student notes that will keep coming on the subject. But we're really not at the point where we really reach the point where we do things that, machine creates like humans and we should treat them like humans, either in the kinds of interest they have in the creation or in the legal rights they get. So let's put all of that aside. What are we left with? With the policy questions, right? And actually, personally, I don't think the policy questions are limited to economics, right? It's questions about human interests implicated, right? Whether economic or otherwise. And I think, just to keep it very short, when we look at works that at least get close to being machine created, right? And there's a deep question of when that happens. There's very little argument for copyright protection, right? So, duration is just an example. I think that no category of work should be protected for a century, but certainly not that. Why? Because what's the big, brouhaha about machine creation? The one main thing is exactly the slashing of costs, right? That it's so much more cost effective to generate stuff that we couldn't in the past for that cost. And cost is the main case for copyright in this area. So bottom line on the merits, I think, and again, the interesting questions, of course, come with the fusion of human creativity and machine creativity. Those are the hard questions. But with regard to pure machine creation, there's no reason really. So bottom line remains to be seen with all the developing models, right, for user creation. But I think at the moment, the direction actually charted by the Copyright Office, as described by the registrar, it's a great reaction to the current situation, right, as described, and then we can wait and see how the technology develops.
Yeah, that's a great point. So just as a bit of background to summarize what you're saying here, the historical view of copyright before technology was, in order to incentivize creators to spend the time, effort, and skill to create a painting or a song, you give them many years of exclusive rights on the back end. But now we're at a moment where we can create high quality outputs at near zero cost. You just type it in. So do we need 140 years of exclusive rights on the back end to incentivize that?
Thanks for translating.
Yeah. No, you're welcome. And that was a great point. All right. Now this is a point that I think is near and dear to many of us, which is, what about the policy impacts of generative AI on creators? So on the one hand, we have these artists out there who are painting, musicians, poets, writers, right? This is how they earn their living, and this is very valuable. And we're moving to a world where AI can generate pretty good versions and maybe even great versions of some of those things. So we might be concerned. On the other hand, we have seen this before in technology where artists and creators say, here's a new technology. Oh no, here comes photography. Back in 1900, portraiture is gonna go away, and then painting. And then when it came to digital photography, they said, oh no, film photography is going away, and then Photoshop, and then, so, there's a lot of new, technology brings a lot of new opportunities, and artists often find new uses for new technological tools in ways we can't anticipate. So we want to be both concerned, but also wary of the past. So with that in mind, let me throw it to Viva.
Right. So you stole my thunder a little bit,
sorry.
because one piece of this certainly is that there has that artists have. I think we've seen in the past with each of these new kinds of copying technologies that artists and creators have managed to adapt. and in various ways. In fact, Harry, you said, before tech, there was this copying. And in fact, there was no copyright before technology. So literally, really, we only have copyright law because of disruptive technology. So if the history of copyright law is really the history of disruptive technology, there's always been this concern, and legitimate, I'm not undermining it, about, well, what's going to happen to the creators. The fundamental point of copyright law is, how do we make sure we get enough creativity? How do we get enough of these things that we like, which are, music and paintings and poetry and novels and video games and everything, all of these things. I think that, Harry, as you point out, sort of the history of this has been that we do seem to keep having human creation. And I'm actually I'm a big optimist on this point. I think that human beings are going to keep creating things. And I actually also think that human beings are going to continue to want human created things. I think it's possible, this is maybe my overly optimistic view, is that there may be even more of a sort of premium put on human created or authentic experiences going forward, given that I think we will certainly have massive, massive quantities of non-human created or AI assisted works. It may lead us, I think we're already in a world, I'm gonna offend somebody here, where we have lots of low value works out there in the world. And I think it's, I put all the photographs on my phone in that category. Lots of, I read a bunch of stuff before this about, TikTok creators using AI to aid them in their TikTok creations. So you can tell how old I am right now. That I don't even know how to use the words right here. I would put a lot of that probably in the sort of low value, again, I'm gonna make somebody mad, space. I think we're gonna keep getting lots of that stuff. And on the higher end, I absolutely am an optimist. I think that so when we're talking about creators and livelihoods, though, that involves, creators are one thing, livelihoods involve business models, and the technology that comes along often does really either seriously undermine or completely destroy incumbent and legacy business models that do enable creators to make money from their creations. And this is one where I think I just put it out there as I don't really know, and I'm not sure anybody knows what's going to happen to people who write marketing copy, to web designers, to graphic designers, journalists, screenwriters. These are all people who I think will keep wanting to create and may have less opportunity because of AI to make money from that kind of creation. And so I don't even know what question I was supposed to answer exactly. But I think that I'm optimistic about humans, but I am very deeply concerned about, in some ways, humans' ability to make money off of their creations going forward. And I think AI has a possibility of maybe being different than previous technologies in terms of disrupting that. So maybe I'll just put that out there as a question.
Cynthia.
Yeah, I think that you touched on a lot of the different industries, and I think that AI might impact them in different ways and in ways that matter differently to the United States. So I'm just going to talk about journalism because you mentioned it. I think, in terms of the industry as a whole, if generative AI is allowed to copy indiscriminately from source material and generate outputs that substitute from that source material, you're going to find it very challenging, as you pointed out, for the journalism industry to continue and flourish. And I think as important as fine art is, and as much as we all appreciate it, journalism is sort of a pillar of our democratic workings. And without the economic incentive to continue to be able to function as a business, the loss of journalism, I think, is a very dangerous outcome to what could be and what seems to be very substitutional use from the GII. So I think that for that perspective, creators are quite concerned, and I think they're rightfully concerned.
That's a great point, because creators aren't just necessarily serving a creative role in society, they're serving other institutional roles. I love that point. Andy.
So, I mean, I certainly share the vision that it would be bad if newspapers ceased to exist. That is common ground. I think I have a little bit of a different perspective on sort of the likely effect of AI on all of that. Really just 2 points to sort of add to the conversation, which has been very illuminating to this point. One is just another angle that has always struck me about the potential of these tools to sort of affect creative endeavors is the degree to which they actually unlock the possibility of people creating who, without this technology, couldn't do it for whatever reason, either because they physically were disabled or otherwise didn't have the wherewithal to pull it together. So just it's another consideration to throw into the hopper as we evaluate all of these competing implications, that there is, I think, unassailably a dimension of this where we're going to democratize, in some respects, the universe of people who can create like really cool stuff that wouldn't previously exist. I guess the other sort of comment that I would like to throw out there, which I don't mean in a cynical way, I just mean in a sort of like realpolitik kind of pragmatic way, is that there's an international dimension of all of this that we should bear in mind, which is that like the US is not the only jurisdiction that matters here. And these tools exist. They are probably going to continue to exist, at least somewhere on the planet. And as we think about kind of what the right rules of the road are to protect all of the legitimate interests that people have articulated in response to this question, I think it's important to do so in the context of understanding that, like, well, we probably don't want to make it so that the way that things happen is just everyone goes to another country that is very hospitable to these tools, and they're the ones who are going to be generating the things that are going to take the jobs that people don't want to see taken. So it's a complicated set of interrelated sort of policy levers to think about, and that's really the sum total of my thinking on those questions.
Yeah, those are some great points, and I want to emphasize one point you said, which is new technologies unlocking new creators and democratizing. And we, 15 years ago, we didn't have the term YouTube creator, and now people spend their livelihoods, using these new technologies. So AI will probably unleash new types of creativity, even as it disrupts existing ones. Katherine?
Yeah, just really briefly, I'm going to keep beating the drum that there are many different types of generative AI models and many different types of generative AI systems. And I do not think that our future is guaranteed to be one way or another. It really depends on what types of products are built with these systems, how they're integrated, and how people are able to use and leverage them. So I can imagine tools for journalists that could be built with AI that would empower them and make their lives easier. Will that necessarily have growing pains? Definitely. But I could also imagine much more sinister versions of our future. And so I think that as we're sitting here thinking about it, I share your optimism for humanity. And I share the optimism that we're going to figure some things out. It does absolutely depend on broader and institutional and governmental interests, but this is not a foregone conclusion. Our future here is not a foregone conclusion. It really depends on how we structure the products that we build, how we structure those models, and how we integrate them and teach people to use them.
That's a great point. Did anyone want to respond to that? Well, I love your point, which is, and this is why conversations like this are so important, that the technology, we shape the technological future, all of us, and it's important not to let the defaults shape it. So I love that point. So I'm going to throw this over to Oren here. So as Professor Reed said, for better or for worse, copyright is often the first on the scene when it comes to technology law like AI, but it's not necessarily the best or the most equipped set of legal regimes to deal with complex issues. What are some of these pitfalls for allowing copyright law to regulate AI sort of by default?
So the answer is that's correct. And I think the premise in the question is correct, which is a lot of those big issues that are arising now, those social concerns and complaints about AI in the realm of culture will be laid at the doorstep of copyright. They are already being laid at the doorstep of copyright in heaps, as we know. And the reason is, in our society, copyright law is the main tool we have for dispensing cultural policy. It's not the only one, but it is the main one, for better or worse. So that's going to happen. It is happening. Now, two things to notice about copyright here. First of all, copyright is and was designed and is built around a particular policy problem and as a particular solution to that specific problem in the field of expression. Copyright is about the problem of undercompensation, attributed to the fact that once you create something and publish it, it's very hard to exclude others from it, and the fact that almost always it's much cheaper to copy than to create. Copyright is tailored to be a solution, at least a partial solution for that problem. Second thing to notice, copyright solution, which by the way, it's not the only one, but copyright solution is market-based, right? That's what copyright is about. The solution it offers is basically it enables creators to sell their creation at marked up prices. So it relies on market transactions. It's market-based, and there are known advantages and disadvantages to that strategy, but that's what copyright is about. Now, enter generative AI in the field of expression. Again, two things to notice about the complaints and arguments and concerns, specifically about the broad legal arguments being made. So the broad legal arguments, when you really examine them, are not about the specific policy problem that copyright is designed to solve. Well, not all of them. The classic arguments about output of generative AI that is substantially similar to copyrighted works, of course, it's about that. But the broader arguments like training copies and copying of style and some other arguments that are percolating up there are the real concerns that drive them are different concerns. And actually, I think they're legitimate and grave concerns. Those concerns are actually reflections of more general concerns about generative AI in society in general and not just the expressive sphere. Just to identify three concerns like that in the expressive area. First of all, concerns about the disappearance of sources of livelihood and human income, right, in the creative industries. Second, concerns about opportunities and potentials for people to engage and enjoy the inherent value of creativity, not the market value, the inherent value of creativity. Third, concerns about the sources and potentials for disruptive innovation, the kind of innovation that doesn't only deliver very well within given patterns, but rather break the patterns. Those are very important, legit concerns. I think those are exactly the concerns that copyright is not built to deal with, was not designed to deal with. And moreover, if we really examine closely, which of course I cannot do in my remaining 2 minutes, each of those concerns, what we would see is that each and every one of them is extra market. It's really external to market logic. And that's not a criticism. I think that's a great thing. But those are the things at the bottom of those concerns. Why? Because the logic of the market is best market efficiency. From that perspective, what on earth could be wrong with generative AI? It delivers wonderful results. It satisfies market demand at great cost efficiency. What's to complain about? All of those concerns in one way or another challenge the logic of the market from this or that perspective. And remember, copyright is market-based, right? That's the logic it adopts. What is the outcome we get in here? The outcome is an incredible misfit, basically between the tool that people naturally go to, copyright, in order to try to solve all of those problems, and the characters of the problems we're trying to solve. And therefore, it's much like trying to use a hammer to do the job of a screwdriver or indeed an entire toolbox. What you're going to get in those cases is a very bad job, and you're going to smash a lot of things.
Those are really great points. I mean, a lot of the issues that are coming up are cultural issues of economic policy, trade policy, competition policy. So, for example, just one, imagine that the courts say that training data is not fair use. As a practical matter, it would make training AI systems either more expensive, maybe slow them down, and that's really a competition issue. On the other hand, it might give new sources of revenues to creators whose works are being used and livelihoods are being disrupted. Again, an economic issue, and we're using copyright as a tool to deal with all these other issues that are outside of its area of expertise.
I'm just going to say really briefly, I think that those economic issues, though, are what copyright law is about. Like, I don't actually view that as being outside of copyright law. But there are other extra copyright issues that I think generative AI implicates, but a lot of the market economic points really are at the heart of copyright.
Can you expand a little bit more on that?
Well, just it goes back to the original rationale behind why we have copyright rights to begin with and why the Constitution gave Congress the power to grant exclusive rights to the creators of those works. It's to incentivize their creation. So the more you take, like on the training data example, if training data were to be found to be a fair use, or the use of training data to be a fair use, you're depriving the creators of a important revenue stream, and that's an economic consequence and a market consequence, and it goes to the heart of like the incentive policy behind copyright.
Yeah.
May I respond quickly?
Please.
I totally agree that copyright, by the way, again, even if the interests you care about at the end are not economic interests, is about the economic dynamics and making sure that we get what we want there. I do think, though, that it is focused on a particular problem within the economic dynamics, especially when we talk about incentives. And it is that problem of not being able to recoup your investments because of the impossibility to exclude others and the gaps between creating and copying. And to some extent, that's of course relevant to the field of generative AI. But I do think that the broader problems are not limited to that at all. For example, the problems of losing sources of income. Much of the issue there, let's be honest, does not come from the fact that the AI free rides on the efforts, at least the expressive efforts of creators that became before. And much of the issue derives exactly from the fact that, annoyingly perhaps, it's so much better, so much cost effective in creating something new out of what's out there in the commons. It's really troubling on some level, right? And it will displace the livelihood of people. It is a troubling issue. It's just not the kind of economic issue that copyright was designed around.
Good point. Andy?
I know we've got to get to questions shortly, but I appreciate your comment about competition in this space and sort of the valence of different perspectives you could take on the IP issues for what that portends for competition in various markets. The Federal Trade Commission actually held a sort of a session on Wednesday in which a number of people aired sort of anti-fair use perspectives, I think, on the use of copyrighted content to train models. It struck me, my background is as an antitrust lawyer, that if you really care about fostering competition in this environment in a way that it will ultimately sort of redound to maximize consumer welfare, which has historically been the gravamen of sort of competition policy, at least for a while now, what you would see the FTC doing, which they probably won't do, would be filing amicus briefs in all of these copyright cases saying the use of this training data should be fair use, because that will, more than anything else, allow for an explosion of competition among sort of the technology side that's innovating in this space. I'm not holding my breath, but sort of from a theoretical perspective, that's how that debate would play out if people were sort of thinking about it in that way.
Yeah, that's a terrific point, linking it to competition policy. So our last question before we open it up to the audience for comments goes to Katherine. So Katherine, how should we address the potential for AI to inadvertently infringe on existing copyrights, especially when they're trained on vast data sets?
So I'm going to answer this from a technical perspective, and then maybe people can chime in with other perspectives. I've been saying this throughout, but there's a lot of choices that you get to make in this process of creating a generative AI system. There's a lot of choices that go into the system. There's a lot of choices about who you work with, what you work with, and how you deploy the system. All of that feeds into how much or how many or what it looks like the copyright infringement looks like. So I I am neutral looking forward to this. I think there's a lot of work that can be done on the technical side to make some of this a little bit better. So one example is using retrieval-based models. A retrieval-based model is a different type of architecture than your typical generative AI model. It takes, it goes and looks inside a data set for relevant works, and then uses that work to inform the generation that it produces. So the advantages of that are that it's much traceable. It's much more traceable. So you can say like, oh yes, if it's going to be similar to something, maybe it's similar to that work that was retrieved. Obviously, this is not perfect, and it's not a perfect solution, but I'm just trying to give you some sense about the creativity in this space that we have to work with here. There's other ways of designing models that can make these issues easier to deal with or harder to deal with. There are also ways of controlling the inputs and the outputs to these systems. So regardless of whether or not the model itself is producing potentially infringing outputs, again, if it's maybe not shown to anyone and it's stopped by an output filter, maybe our case here is a little bit easier. So I started this process talking today about exact memorization of training data. That's a really easy case to catch as an output filter. You can just say, hey, does this generation look exactly the same as any other piece of training data? But it's actually not that easy, because how much of that generation needs to be exactly the same as something in the training data? And that's a question that I'm not going to answer, because as I believe, there are entire volumes of work written on substantial similarity. And for the record, I think that there is no easy, simple technical solution here, but that doesn't mean that technical methods can't help improve this problem. So don't want to be technical solutionist and say that, yes, there is one function that I can give you, and if you call this function, it will be fine. I do not think that's the case here. But that does mean that we can produce things that like look at the lighting of different images and compares that, looks at bits and pieces of the images and compares that to the training data, looks at different ways of capturing style, capturing and measuring style, and all of that can inform the decisions that we make downstream. So I'm going to reiterate this point again. I'm pretty optimistic. I think there's a lot of different choices that we have in this process and in this pipeline. People are getting really creative about how they design their model architectures. People are also exploring other ways of creating and collecting training data that may change this entire analysis. Whether or not someone uses their own model that they have trained themselves or uses a model off the shelf, and how they interact with that may also change the copyright analysis here. So there's a lot of different actors, a lot of different choices being made. I would love for us to design good incentives so that the choices in the future that we have align with our values.
That's terrific. And I think especially the focus on the input and the output filters is a good idea, and something we're starting to see happen today. So just last night, GPT-4 recently came out with DALL-E 3 integration. And I typed in, hey, would you produce, a version of this copyrighted character and this copyrighted work? And it refused. It said, no, I know these are copyrighted and I'm not going to do that. So I thought that was fascinating. Anybody else want to weigh in on this? Yeah, Oren.
So I just want to quickly provide like the book match version on the legal side to what Katherine is describing on the technical side, which I guess I totally agree or just bow to her on the technical side. I would just describe it not as, endless set of choices, but rather what arise out of those choices are different models, right? And I think similarly on the legal side, what we get is different legal models that should deal with those different models on the technical side, specifically on a very general level, to the extent that we go down the food chain, right, of using the AI, up to the level of the users who put in the prompt these days. Legal doctrines that will be more relevant is direct infringement doctrines. To the extent we're going up the food chain, and the food chain could be very complicated with many links in between, we'll probably have to go to existing secondary liability doctrines as we know them, and it's not that all is fine in that area, but that's what we'll have to turn to. And then, interestingly, possibly we'll have to add more. We might need to think about some other innovations, either through some sort of internal regulation or add in, and some people won't like that, some sort of an idea of a negligence standard on the secondary liability level. But we'll have to match the different technical models and food chain with different legal structures.
Yeah, great point. Cynthia.
I just wanted to say something about the sort of the nomenclature. So I think that the idea of inadvertent infringement, I'm not sure inadvertent's the right word. I mean, in copyright law, for things that are registered before the infringement began, at least, you talk about willful infringement, innocent infringement, not really inadvertent. And so I think that there's, and you can be a willful infringer if you do something that's sort of in reckless disregard for a copyright owner's rights. So I think that depending on the stages at which you're looking at the use and the alleged infringement, some of what people might use the word inadvertent might actually be willful from that reckless perspective, because I think people ingesting huge quantities of data, like they are doing it knowing that they're ingesting things that are copyrighted, and if they have a genuine argument that they think it's fair use, that might impact those findings of willfulness or recklessness. But I just think inadvertent is a difficult word to use when you're talking about copyright infringement.
Are you suggesting I didn't make a genuine argument?
Well, thank you for that. That's important. Words and their meanings matter in law. So let me toss this out to the audience for some questions, in particular, student volunteer. We got an eager student right up front.
Thank you for this panel. This was very insightful. So I'm thinking of how to phrase my question, and going to Oren's point of there might be a reduction in economic costs essentially associated with using generative AI models to generate artwork, stuff like that. Given that the whole reason behind copyright law is to provide individuals the economic benefit derived from their work. How do we account for those decreasing transaction costs, if you will, when applying copyright law to AI generated works of creative works, if you will?
I'm happy to respond.
Yeah, you
just
want to take that?
Look, so again, I'm going to answer on a pretty abstract level, but hopefully it will be responsive. Remember my basic take on certain economic costs, or at least worrisome economic effects. My basic take is that the strongest reasons why those effects are concerning are not market efficiency or anything like that. Like, there's something really concerning if a large amount of people lose their livelihood in creative industries, right? Now the question becomes, again, what's the best way of addressing that? And you remember, I don't think that classic copyright law, property rights, is the best way of addressing that, among other things, because of transaction costs. But that's not the only reason, right? The market, for example, compensate people according to market success. I'm not sure that that's what we want to do if we have other concerns. So the abstract answer is, again, there's a whole set of institutional choices that with a continuum all the way from classic private property rights, copyright, to a really public general tax and transfer scheme, right? And in between, somebody mentioned it, but we haven't really discussed it yet, you might find other institutional options like general compulsory license for a flat rate or something like that. So there's a whole menu in between market solutions and completely public tax and transfer solutions. The only thing I would still advocate is, even if we go for a solution which is not extreme on the continuum, not all the way to some general tax and transfer, let's keep in mind what we're trying to do here. And again, and I think what we should be trying to do is not necessarily mimic the market and its outcomes. Therefore, even if we have a compulsory license, I would argue that the compulsory licenses fees shouldn't be calculated by some hypothetical market transaction formula, but rather by something else. Hopefully that's responsive, but it's pretty abstract, I guess.
Yes, thank you so much.
Okay, we've got a question in the back.
My name is Vicki Mandel, and I'm a consultant. I have my own law firm. And I have a question for Kathy Lee, because it is quite of an opportunity to be able to talk to a machine learning researcher. And Kathy, you've talked about all the decisions that are being made while the machine is learning and being trained, sort of human decisions that are guiding the growth of the machine and the learning. And so I was wondering if you could give some examples of those decisions that are being made. And I'm particularly interested in examples that have to do with teaching the machine to be ethical. And I realize this is a little bit outside of the copyright question, but I'm very interested in AI regulation generally. And that's one of the big issues, is how to teach the machines to make ethical decisions. So any examples at all, but those that focus on ethical value, moral choices are especially interesting. Thank you very much.
Yeah, so this is a really interesting question, because from my perspective, copyright is only one of the many issues that generative AI raises. And on a technical side, like copyright and privacy and potential IP leakage all have similar technical roots. And if you pull back even further and say, like, what's the goal here? The goal is to make useful models. What is useful? Sometimes useful is creating copyrighted content. Sometimes useful is not creating copyrighted content. And the process of creating a useful model requires alignment. Alignment is a word that is very overloaded in the technical community. So to give you a very brief summary of it, it's basically constraining or structuring or guiding models to do things in accordance to the way their human creator wants them to do. So there's many different ways of implementing alignment, and to generate or to not generate copyrighted content, it could be thought of as one subset of this alignment problem. There are other subsets, including, like I said, privacy, which is like, don't reveal anyone's private information. That could be a value that we hold that we want to imbue into a model. So some of these techniques include things like reinforcement learning by human feedback is something you may have heard. That means we're collecting a bunch of human labeled data that somebody has said okay and somebody has said not okay, and then giving that as part of the training process of the model. So that's one thing that you could choose to include or choose to exclude. The data collection process of collecting the human alignment data is also a factor in this. And different people may ask different actors and different model trainers may use different communities to respond to that information. So that's just one choice. That's like a data curation choice. There are other choices that we've already talked about, like data set size and scale and exactly what's contained in it, like licensed, non-licensed data. You can ask the same questions for private, not private data. Again, the word privacy is also really overloaded, both on the technical side and on the legal side, I'm given to understand. And so not getting into that, but yeah, there's a lot of curatorial decisions here that all play into that. I gave another example, which is retrieval-based models. Another example for alignment is using the output filters or choosing parts of your training data to use or to exclude to change the biases of the model. That's another version of this. Another one is prompt tuning, which is a way of designing prompts, the prompt that you give to the model, to guide it in one direction or another. So you've probably seen some of this before, which is to say, like, some people have been jailbreaking these models. And what that means is they try to go around the alignment that model creators have put on the model by giving it prompts that are unexpected and put it into different scenarios. So there's, again, a whole plethora of different choices that could be made here, and also of different actors who have different responsibilities to different people, and who may or may not have responsibilities to each other.
Great, thank you. And we have time for 1 minute, one quick question. So if we can ask it asked quickly and answered quickly.
So this is a very simple question, but a tough answer. What do the panelists think about giving humanity itself time to transition over to the adoption of the generative AI? Because it's literally going to disrupt every single area of the life and put livelihoods at stake.
I mean, if you're referring to kind of the pause, I'm not a fan of it because I don't think it's particularly effective. I think there are other ways to do things more directly, but I'll open it up to the other panels.
I think the technical community is very split on this. There are people, and again, it matters what AI you're talking about. If we're talking about like creating like a photo sorry, this is a bad example. Let me roll back. Okay, there are different levels that we're rolling out products in, right? And some of those things are general purpose products, and some of them are much more specific and more narrow. So I think maybe thinking about it in that frame and thinking about how we can engage with folks who are part of those communities or those industries to create products that they are actually excited about and are useful for them could be one different approach for that. But the technical community is also extremely divided about how exactly to approach this question.
Well, thank you for a very interesting panel. Please join me in thanking our panelists here.